Hello, and welcome to Innovation Unlocked by Mathys Squire, an intellectual property powerhouse, bringing you the top insights into inspiring inventions and booming businesses and how to protect them. I am your host, Andrew White, and today I am joined by my colleague, Nicholas Fox. I think today we're going to talk roughly about sort of the future of patent litigation, quite a mysterious sounding subject there, but I think it's based off the back of the Unitary Patent coming into effect.
Well, that's just it. It's a case of interesting times with patent litigation. And as you said, the big change which has happened here is the Unitary Patent and the Unified Patent Court.
So could you just maybe, for our listeners who aren't quite so familiar with those two concepts, just explain them to them briefly?
So the easy one to describe is the Unitary Patent, which is a patent which covers multiple countries. And it's a group, but not all, of the EU countries. Mm-hmm. So it includes, for example, France, Germany, Netherlands, Italy. For various political reasons, and it's a classic case of Euro fudge, it doesn't cover Spain or Poland, and it doesn't cover the UK because of Brexit. Mm-hmm. But allied with that, having this single patent right which you can enforce, they also had to create a new patent system, and that's the Unified Patent Court. And that's got a number of aspects to it, but essentially the idea is you can bring a single court action in Europe to enforce patent rights in those countries which have signed up. And those patent rights can come in two types. There's this new unitary patent, and there's also conventional European patents granted by the European Patent Office. So what happens, everything gets prosecuted in the European Patent Office in the usual way. When you're told by the European Patent Office everything's in order, then you have a choice. Either you get a bundle of national rights in those countries which are participating, so you get a European patent Germany, a European patent France, etc., and you get to choose whether you maintain them there, or you get a single unitary right which covers all the countries which are participating.
Okay. So as a patent attorney, I'm a chartered UK patent attorney and a European patent attorney. So that means I often act before the European Patent Office. And you talked about sort of the European Patent Office granting patents. Is the UPC related to the European Patent Office, or are they different bodies, or what's the relationship?
It's a mixture of two things. So it's a separate body because it's a separate court. But, and this is obviously an important aspect of this, European patent attorneys, anyone who's qualified as a European patent attorney, has the right to appear before that court, and provided they have certain qualifications, it's about 68 to 70% of UK patent attorneys have those qualifications. They can bring cases, they can litigate as well as appear before, without the need of a separate lawyer like me.
Mm-hmm. Mm-hmm. So this UPC and Unitary Patent system, it's been going around about 2 years now, I think, roughly.
Coming up, yes.
Coming up to 2 years. We've now got some data then. We've got some insights into what's happening. I think that's what we're going to be talking about today. Is that right?
That's what I think is really interesting, because you can see some certain trends going on, mm-hmm. And you can also see how things might happen.
So, okay, let's go. You know, what are we seeing? What's happening? What are the trends?
Well, this is the fundamental question. First of all, there's a question of how much litigation there is, mm-hmm. and that needs to be put in context with how much litigation there was. Mm-hmm. Unfortunately, the Unified Patent Court has quite an idiosyncratic way of creating its statistics. This is because they're primarily looking at it from an accountant's perspective. They want to know how many cases a judge needs to deal with. Mm-hmm. But that means there's a lot of double counting in their official statistics. Normally, for most courts, if you have a enforcement action and a corresponding revocation action, and maybe provisional measures actions related to the same patent, that counts as one case. the Unified Patent Court has a tendency to look at all of these and say, okay, we've got one case for the revocation action, one case for the infringement action. If we have multiple defendants, maybe we'll have 2 revocation actions, so the number's a little bit unreliable.
Okay.
But just focusing in a way which is comparable to the figures we've got for national courts, in the first year, there were a total of just over 200 cases in the UPC. Most of those were infringement actions and their associated revocation actions. A handful were standalone revocation actions, and also that covers the 204 figure covers preliminary measures actions, so actions for preliminary injunctions, obtaining evidence, etc., etc.
And how does that compare to national litigation elsewhere in Europe and the UK?
Well, this is where it starts getting interesting, because this is looking at how does this play through. One of the key questions with bringing in a new system which makes enforcement easier and cheaper, is that increasing the amount of litigation, or is that instead just moving litigation from one court to another? So looking at figures from 2021, why 2021? That's because those are the latest figures we've got from Italy.
Right, okay.
It's taken a little while for the Italian courts to produce their updated numbers. But looking back to 2021, around about 60% of patent litigation in Europe took place in Germany. And there were around about 800 cases there. So, and the other countries are far, far fewer than that. Under 200, under 100. Putting things in perspective for the UK, we had 50 cases that year.
Okay.
And they're not evenly distributed. Once you've got past the UK, the numbers in each other country gets much, much smaller.
And why are there so many more in Germany?
The reason why there's so much litigation in Germany is they have a bifurcated litigation system. Like most of these wonderful ideas, it's all come about by accident. There's a very good constitutional reason, but the reason why it's been so popular is accidental. So in Germany, they separate the question of party-party litigation and party-state litigation. And the question of whether or not a patent is infringed is a party-party question. The question of whether a patent is valid is a party-state question. And those proceed in different courts. And as it happens, there's a delay or longer delays, bigger backlog for determining whether a patent is valid than whether it's infringed. And potentially this can put a alleged infringer into a very difficult position, because if the German courts determine that
They could be infringing, but the patent is indeterminate.
Exactly, they determine,
validity, right?
yes, this product falls within the scope of this claim. Before you have a ruling, this patent is valid. And once you've got a determination at first instance in the German courts that their infringement has been occurring, there is the possibility of getting an injunction and using that as an enforcement mechanism to come to a favourable settlement.
But even accounting for bifurcation, right? The numbers in Germany are far more than double those in the UK.
Oh, considerably. English litigation has got separate problems. There's a big difference between common law, what's Anglo-American style litigation, and continental civil law litigation. And our costs are very high. So normally a patent action in Europe, obviously it depends on how big it is and how important it is, but it's not unusual to be 100,000 euros in costs, legal costs. Whereas equally, it's not unusual for a UK litigation to be closer to £1 million. And that's a significant difference.
Yeah. So Are you seeing any other trends? We talked about the data from 2021. Are we seeing other changes in the data over time in terms of sort of UPC cases, what's being decided, the caseload?
Well, those are where things are getting interesting, and you can look at it in two ways. First of all, there's the caseload, and there's also the question of who can do this and where things are likely to go. So taking the first of those questions, the caseload. So we've started to get these data points, and the clearest one is what's happening in Germany. So take our baseline 2021, around about 800 cases. In the first year when the UPC was opened, that was around about 600 cases. And the most recent figures we have, which is for 2024, that's down to 550 cases.
It's quite a change, isn't it?
It's a clear trend, and what that suggests, because Germany was the key court system where litigation was being brought, is that a lot of the European patent litigation which was happening in the German courts has transferred. We're starting to get some figures from some other courts, and things aren't quite so clear cut. In France, it's we're waiting for the 2024 figures, but in 2023 the numbers went up slightly, but practically level.
Yeah.
The UK numbers again are fairly flat, but there are differences in the nature of the cases which are happening in the UK. Because of the costs, they tend to be bigger and more important cases.
And do we know who's responsible for the litigation in the UPC? I mean, is it a case of the same lawyers in Germany are now doing the UPC work, or how's the profession changing?
It's a mixture, but I think it's a question of early days here. I know I mentioned to you before we spoke that there's an interesting analogue here with what happened with the patent profession. So, of course, the patent profession, there was a big bang when the European Patent Office opened. That happened in 1978. And practically, if you look at the British numbers, the numbers of patent attorneys stayed the same for the next 20 years. And that was because there was a shift from the UK Patent Office to the European Patent Office at the same time as the numbers of applications in the UK office dropped because they no longer had to go there. They could have people could have a central, and so what that suggests is that initially, unsurprisingly, people use their usual providers. If most of this litigation used to be German litigation, it's not surprising that a lot of the cases are being represented by German lawyers. But there are other trends going on here. One of the big things here is that the Unified Patent Court has given the opportunity of patent attorneys, European patent attorneys, to be involved in litigation directly. In most countries, that's not possible for national litigation. You had to bring it in through national lawyers. But here, it's different. Now, it's early days yet, but there are good reasons to think that at the same time, you have a reduction of duplication of litigation, which is the purpose of the court in the first time. An increase intra-European competition with European lawyers. You've also suddenly got this big cadre of patent attorneys who are also able to appear before the court. And that is starting to happen. How that plays out, it'll take time to see how it does, but it is a significant question of how things go. The big advantage for patent attorneys is that if you look at the numbers of cases, I mentioned 200 cases, there are 10 times that number of oppositions at the EPO. And that gives, and oppositions at the EPO are almost entirely undertaken by patent attorneys. And that means there's a big volume of cases where people can keep on practicing their skills.
Yeah.
And there's definite huge similarities between the EPO approach and the approach of the UPC as it comes to patent law.
Yeah, I mean, I think as we're recording this right now in the room next door, a couple of our colleagues are involved in an opposition, as we speak. So, yeah, lots of experience of handling oppositions for European patent attorneys.
I think that's the big point. Yes, there are occasional patent wars that go on where you have lots of disputes between two individual companies or groups of companies. And that means there's a series of patent cases in terms of litigation. Mm-hmm. But it's nothing like the continual stream of oppositions. Mm. And crucially, it has become apparent as we've started getting case law from the UPC that the style of litigation there is, first of all, very European. It's civil law litigation, which is more like the work which European patent attorneys do. And secondly, it's very much focused on the science. Mm. I'm afraid I'll have to be guilty of this being a solicitor, but solicitors in patent litigation, there's an element of playing the procedural games. And that doesn't happen so much in civil law litigation, partly because it's almost entirely written. Yes, you've got deadlines and so on and so forth, but it's not quite the same as positioning that happens in UK litigation. And it's similar with EPO oppositions. All that matters is what you end up submitting to the court in written arguments. Mm. And then you have a chance to supplement that at the oral hearing. But the key areas where you win are in your written arguments, not solicitor correspondence.
Yeah, so it does sound very much more similar to the European opposition process than national litigation.
There are obvious differences. One's probably irrelevant, and the other one is a little bit more interesting. The irrelevant one is obviously there are questions of infringement, but generally whether or not something infringes, it's practically identical to whether or not a patent's novel.
Yeah.
So either it's there or it isn't. And you have to establish the evidence that you have there. The other side are, which does need to be considered, is there is procedure which needs to be taken into account. The CJEU case law on this, that, or the other, whether or not one court is responsible for this, and what happens when someone sues simultaneously in the German courts and the UPC. So there are procedural elements, and of course when you come to the final enforcement matters, actually getting a court order enforced or getting money out of people is not something which flows directly from an opposition.
Yeah. Are we seeing any other trends with sort of unitary patents and UPC litigation? I mean, are we seeing sort of people opting in for unitary patents in the same sectors that we're seeing the litigation happening in? Is it particular sectors there's focuses in? Is it?
Well, as far as the unitary patent's concerned, the uptake there has been really quite enthusiastic. Mm-hmm. It's difficult to compare year on year because we've only got 18 months. And because the first year was a bit odd, and it's brand new. But
of course, yeah.
It's the numbers of the uptake has been quite high. It's between 25 and 30%, or around about that. So 1/3 of European patent applications are becoming unitary patents.
It's quite a high figure, yeah.
But there has been a big difference in different technologies. Quick pop quiz for you. Can you guess the technology which is most popular for getting? So, got various different technologies.
Medtech.
Furniture.
Okay, interesting.
But that actually, furniture and civil engineering.
Mm-hmm.
But actually that fits in, again, with historical patents. Broadly, if you divide technologies into three, there's mechanics, chemistry, and electronics. Chemistry, life sciences, because you tend to have fewer very, very valuable patents.
Mm-hmm.
And because of that, there are procedural advantages for maintaining a patent a little bit longer,
Mm-hmm.
and hence the risk of central revocation is something which makes going for the unitary patent, which is always liable to be revoked in a single court action, a little bit more popular. Go the national route.
Mm.
The opposite happens in electronics. For electronics, it's a numbers game. You get your average mobile phone; it's got thousands of patents covered in it. Why? Because people are discussing standard essential patents, and when you're looking at licensing standard essential patents, it's a question of my pile's bigger than your pile. The flip side of that, when you're looking at whether or not to go down the unitary patent route, is that it's cheaper to get patents in UK, Germany and France only than to get a unitary patent. The reason being you don't need to translate the whole thing. You only need claims translation into, if you're prosecuted in English, French and German. And the saving there, even though on an individual patent it's not very much, £3,000, £5,000, whatever it might be for the translating the description, when you have a lot of them, it makes the unitary patent less attractive.
Yeah.
Now that may change. The regulation says there's meant to be a review whether it's necessary, and that's meant to come in. It's either 6 or 7 years. I forget exactly.
There's still a few more years to wait.
It's got a few more years to wait, and you know very well that machine translation has been getting much, much better. However, that's an English perspective. It's not quite so. It's good at the major languages, but if you want to see how machine translation translates that nice English patent into Slovenian or Hungarian, that's where the work needs to come in. And because this is an EU-based thing, and because there is clearly felt to be the need, understandably so, that people should be able to understand what the patents say, you need the quality.
Yeah, definitely. So the Unitary Patent and the Unified Patent Court jurisdiction, is it just limited to the states that have signed up to the Unified Patent Convention, or is there potential scope for jurisdiction to be a bit further than that? I've heard talk of something called long-arm jurisdiction. What's that?
Well, there are two parts to that. The convention itself provides for a very limited form of long-arm jurisdiction, just how it's all written, that you can, subject to certain requirements, get some damage for infringement which occurs outside of the UPC member states, if there's an act if there are assets in the UPC, largely irrelevant. But there's a much more interesting aspect to this, which is currently developing, but is making big headlines. And none of this is actually new, but it's a sort of wake up and appreciation. The CJEU has been ruling on questions of where you have someone who's domiciled in a country and you sue them in the local court, and then you try and enforce rights which occur outside. Now, none of that's new. The whole idea of the Brussels Convention is that people ideally should be sued in their local court where they're at home. They can, as an alternative, they can be sued where an act of infringement might have taken place. But there are benefits if you sue them in your local court.
Right.
What we've recently had is the application of this rule in the UPC.
Is this BSH and Electrolux?
So BSH and Electrolux is the Swedish court where the CJEU have been talking about this. But what I'm primarily thinking about, it's Fujifilm and Kodak.
Okay.
So two wonderful names if you're thinking about cameras. But the point there was that the company which was being sued was based in Germany. Germany is a UPC contracting state. They were sued in the UPC, and for those purposes, the UPC is a German court. And that meant the UPC has ruled that it had jurisdiction not only over patent infringement in the UPC, but also patent infringement of corresponding European patents elsewhere.
But is it a German court?
The UPC has said so, and and according to the revised Brussels Convention, the UPC is effectively a national court. So for those countries wherever it has been established. So it's a realization that's what the law says rather than something which is actually new. Of course, this raises other interesting questions. First of all, this clearly demonstrates that the UPC is potentially somewhere you might be able to enforce against a UK patent. Admittedly, it's restricted. You would need a European infringer. But if a European infringer, a UPC-based infringer, is infringing your UK patent alongside infringements occurring in the UPC, you could potentially bring an action there and take advantage of the fact that it'll be cheaper than bringing an action in the UK courts. The other one, which is interesting, and I don't know how this is going to play out, at the moment, Ireland. Ireland's not a UPC member state. That's because in order to join, they needed a referendum. And that was originally going to happen and then was postponed. And the intricacies of European patent law isn't really normally what the general public is particularly interested in doing. So they tack it on when they're doing something more interesting at the same time. But the consequence of this domiciled, a lot of American companies, big American tech companies, are, for tax reasons, it's always tax reasons.
Yeah.
For tax reasons, are domiciled or have branches domiciled in Ireland. And if Ireland were to join the UPC, that would provide potentially a way in for all of this for the tech companies. That's an interesting question for Ireland, whether it actually wants to join the EPC or not. There are arguments both ways. The rights of Irish lawyers or Irish patent attorneys to bring actions aren't dependent. Just like UK patent attorneys, the UK is not a member, but if you're a European patent attorney, you're in. And similarly for lawyers, the test for whether you could litigate before this court is down to whether you're an EU lawyer. It's not it's not whether you're a UPC member state lawyer. So they can already act, but joining the UPC would mean that these Irish domiciled, Irish established companies potentially are going to be more open to a broader range of UPC patent actions. And how that would play out might mean you've got the conflict there between wanting to be a good group player playing within Europe, and the tax side of things, where you might want to have benefit, and might possibly have a benefit by being outside of the club.
Interesting, very interesting. So just to sort of wrap things up a bit, we said we'd talk about the future of patent litigation in Europe. What are your thoughts? What if you get to extrapolate sort of 2 to 5 years from now? What things do you think are going to change? What things do patent owners need to be mindful of?
Well, looking at for patent owners, it's good times, because assuming the UPC delivers on its promise, and there are all signs that it will do, there is a competent court for enforcing patent rights, and it looks like it'll be cheaper and easier than it is before, and hence that improves the enforceability of European patents and should improve the attractiveness of European patents. As far as the litigators are concerned, it's a case of interesting times. I suspect that it'll be a bit of a battle royale out there. Different players have got different interests in this game. Where you're in Germany, for example, Germany's got the market share to lose, and therefore it's a little concerning. On the other hand, obviously the German lawyers have got a established practice where there's a lot of litigation. For the less patent busy jurisdictions, there is a definite problem. Most European patents are only validated in a limited number of countries, and therefore it's not an instant obvious thing to do. Okay, I've got patents in France, Germany, and the Netherlands. Let's use a Swedish advocate in this particular case. So you've got. I suspect what's happening at the moment is there's a lot of competition, and that's obviously good from a patent proprietor's perspective, because there are lots of litigators who want to litigate, and you add to that the situation with the patent attorneys. This has opened up a cadre of qualified people who know the patent law, and it'll be interesting to see to what extent the patent attorneys take advantage of all this. Interesting times.
Excellent. Well, on that note, Nicholas Fox, thank you very much for joining us today, and thank you.
Thank you very much.